Well, I wanted to start by thanking Marie-Lau, first of all, for putting together such a wonderful conference and inviting me to participate in it. I'm actually going to try to pull a few threads from her introduction and from Dan's keynote to see if I can help talk a little bit about the way that I think that human rights violations are actually contributing to the aggregation of autocratic power. And in doing so, I'm going to do something that's very kind of un-American because, and that is to take human rights seriously. U.S. legal scholars tend to focus on civil rights, and the United States has tended to kind of, as we know, shunt aside human rights, saying that they might sacrifice our sovereignty. And we have lots of laws already, like civil rights, that are going to take care of everything that human rights would otherwise do. But I actually do think they're really important. And taking a key from Marie-Lau's introduction, she pointed out that a function of democracy is to protect human rights in the first place, right? Particularly the protection of minorities. And I also want to try to apply Dan's keynote about the dark underside feeding on the upper world's light good side of things from Stranger Things. So protection of human rights, right, is held up as a counterpoint to Giorgio Agamben's state of exception. And the idea of recognizing a particular harm as a violation of human rights is important for two reasons. In other countries besides my own, right, it evokes a set of legal protections, and it also gives us a sense of the moral valence of the action. When it violates human rights, we feel something ethical or moral about that. So violating human rights should therefore put a government on, number one, shakier legal grounds, and number two, should also pose a threat to its moral legitimacy. So my question is whether there are actually ways in which violating human rights can result not in either one of those things, or maybe one of them, but can actually result in the accumulation of autocratic power while maintaining the appearance of democracy that we recognize from the concept of illiberal democracy. And in exploring that, I want to begin with the foundational concepts from Hannah Arendt and Giorgio Agamben from the perspective of an autocrat who is establishing an illiberal democracy. It's necessary to create both Agamben's state of exception and also make sure that the political indifference that Hannah Arendt talked about is also in play in order to make sure that those who are most impacted by the state of exception kind of receive that political indifference by the majority. And I want to do that by exploring, hopefully, 4 examples. And I just want to belatedly start my timer myself. Because my conclusion is that each of these examples, family separation, summary removals to the CCOT torture prison in El Salvador, the mass deportation infrastructure in the United States, and the pushbacks in the EU, that all of these illustrate ways in which violating human rights actually provides opportunities for governments like this to call upon legal frameworks that create that state of exception. So let me begin with family separation. In April of 2018, the Trump administration announced the zero tolerance policy, this idea that we will prosecute everyone who crosses the border without authorization under the illegal entry or illegal re-entry criminal grounds in the United States. And that was going to include parents who are traveling with their children. So because parents were entering criminal custody, and you can't take children into jail, they were reclassified as unaccompanied minors, and that meant they could be transferred to the Department of Health and Human Services, but with no reunification system in place if, as happened, parents were ultimately deported. And that the children, of course, were placed in these cages in the meantime before they were transferred to the Office of Refugee Resettlement. So between May and June of 2018, the Department of Homeland Security separated over 5,000 children from their parents. At the time, the administration was a little cagey about whether or not they were actually doing this. DHS Secretary Nielsen said, she tweeted, because that's how we do policy in the United States, she tweeted, "We don't have a policy of separating children from their parents, period." In the meantime, from the other side of the platform, the Attorney General Sessions was declaring that separating children was part of the zero tolerance policy and that it was necessary in order to deter parents, from committing crimes, immigration crimes, and also as a form of punishment because the parents were effectively smuggling their children. As we know, the administration then lost track of thousands of children and their parents and basically disconnected them. We're still looking to reconnect, I think, hundreds of children since that point in time. So let's just take a quick look at what human rights violations we can kind of start with. And I'll just give you a couple, I'll just give four as examples. I'm not actually trying to prove that if a lawyer brought human rights claims in the United States that they would win. What I want to do is gesture towards the human rights violations that I think occurred as a result of separating children and seeing what happens as a result of that. So at the very least, we can kind of point to special protections for children, non-punitive treatment of children and parents, the right to family life, et cetera, et cetera. And you can kind of go off the end of the screen and I'm sure of a few more yourself. And I say, maybe we don't need to enter into litigation around human rights because a judge in the United States using civil rights and other procedural laws enjoined the separation and Trump ordered it to stop. But my interest instead is, what did the administration get out of violating human rights in this circumstance? How are they used, these violations used to accumulate power? Because I think that the family separation policies were actually intricately tied to the Trump administration's zero tolerance policy. We know that the United States has criminalized unauthorized crossing across borders since 1929. I could go into why that policy was actually created for racist grounds to keep Mexicans out. But that criminalization of migration-related conduct is one of the three facets of crimmigration, the intersection of immigration and criminal law. And I and others have written quite a lot about how crimmigration creates these sort of broad zones of discretionary agency power that are both opaque and insulated from judicial review. So zero tolerance relied on the second facet of crimmigration, the criminalization of immigration conduct. And here's how I think that allowed the administration to tap into sort of more sources of power that come from particular legal frameworks. What are those legal frameworks, right? I think there's three. The first is criminal law. In justifying family separation, the government called on three aspects of criminal law. So we need to deter families from crossing. In other words, we need to deter families from violating the criminal law of illegal entry or illegal reentry. We need to punish or deter or deal with in some way criminal smuggling of non-citizens across the border. That would be the criminal smuggling by parents of their children. And then Nielsen, in justifying the policy or non-policy, said this is just the same as what happens with any parent who goes to prison for committing a crime, right? Parents in prison don't get to take their children with them. Separation of parents and children is a normal part of punishment for crime. These justifications do two things. They both expand executive power and they normalize it, right? So they create that state of exception and they feed into that political indifference. So according to this justificatory framework that the administration was offering, family separation is just a normal part of the criminal justice process, right? What every parent goes through. And the actions that these families were taking in breaking the law by crossing these borders requires a response from the government that's grounded in criminal law. When somebody commits a crime, it's normal that we would prosecute them for it. So, in other words, everything is normal here. It's also exceptional, and this is a really important part of what the government got out of this. This group of parents has done something extraordinary. It requires an extraordinary response that goes beyond administrative measures for immigration control and requires the criminal apparatus of arrest and prosecution because it is so extraordinary for parents to do this. What parent would? That also gets us into the second framework, which is the immigration framework, right? So family separation also requires greater powers under immigration law right? Because we need to ensure that parents in particular are not violating immigration law. And so we need to use the exceptional powers largely insulated from judicial review that immigration law allows the government to take on. Children are reclassified, or classified, I should say, as immigration issues because they become unaccompanied children in the language of immigration law, and therefore become subject to agency jurisdiction to detain, while a different agency, right, is deporting their parents. And the third legal framework, which goes to the third justification, attacks the parent as a parent. So it justified parental separation on the basis that the parent is unfit, because no fit parent would take their child on such a dangerous journey. And what do we do when a parent is unfit? The legal concept of parens patriae means that the state is empowered to step in to protect this now vulnerable child from its basically abusive parents. So that's how the violation of human rights creates the opportunity to expand to create this state of exception. It's not just the zero tolerance policy that does this, of prosecuting everybody. It's not that opens the door to this aggregation of power. The administration can tap into these larger pieces of power because of the violation of the child and the parent's human rights, and not until then. In other words, family separation is necessary to deter parents specifically using criminal law. It's needed to invoke the crime of smuggling. It's needed to enable the mass detention of parents. And it's needed to justify, via parens patriae, the handing over of thousands of Central American children, right, to the government. So that's my first example. The second one, of course, is CICOT and the Alien Enemies Act, right? So in March 2025, Trump invokes the Alien Enemies Act by proclamation. And to make it legal, he says, well, we have alien enemies. We need some kind of invasion. We have alien enemies in Venezuelans that the government suspected of being members of the Tren de Aragua gang, orders their arrest, detention, and summary removal, and declares that Venezuela, as kind of the enemy state, had created this hybrid criminal state by just allowing the gangs to take over and conduct irregular warfare in the United States. That sets the stage to kind of test these more powerful executive powers like the use of the Alien Enemies Act, which had never, ever before been used in this way. And immigration officials hustled 250 Venezuelan men onto a plane, and a couple of other people as well, like Abrego Garcia, fly them to CICOT, this notorious torture prison in El Salvador. When family members protest that there's actually no connection between gangs and their family members, the immigration official responds in with a very specific legal framework, the securitization framework, saying the lack of specific information about each individual actually highlights the risk they pose and demonstrates that they are terrorists with regard to whom we lack a complete profile. Very appropriate. Then, of course, the administration admits that they had erroneously deported two of the men, including Kilmar Abrego Garcia. He was a Salvadorian who had obtained humanitarian relief from El Salvador in the form of withholding of removal. And so what we see, of course, after that is public outcry, filing of lawsuits, and then the proclamation is enjoined as unlawful under the Alien Enemies Act. Okay, so the human rights violations, again, I don't think I need to spend a lot of time on this. They're pretty stark. We can start with torture. We can end with arbitrary arrest. You can put whatever other ones you can think of into a similar box. I put three up there. But my question, of course, is in what way do these human rights violations allow the Trump administration to tap into legal frameworks that allow them to aggregate power? In a funny way, this one actually looks like a diminution of power, right, of autocratic power. Because number one, the administration ultimately kind of lost before the Supreme Court. The Supreme Court said you can't summarily arrest and expel people under the Alien Enemies Act until you've given them notice and a hearing. And it required the administration to, quote, facilitate returning them. But ironically, the augmentation of power lies in the Trump administration's claim to powerlessness, because the Trump administration told the courts that it didn't have any power to return people from El Salvador because they had ended had no power after the person had left the United States, and that person was now under the jurisdiction of a foreign sovereign, despite the fact that El Salvador was telling them something different, but that's okay. Because I think that this claim of powerlessness is actually an assertion of extraordinary power. If that's true, then once the administration has arrested, detained, and expelled anybody that it wanted to, there's no recourse, right? There's nothing to be done. And the US Supreme Court solution, I think, bears a closer look, because what the Supreme Court said acceded to Trump's power in two really important ways, right? So first, it required the Supreme Court, it limited the lower court's power to require the administration to return people it had transported to other nations. Because the lower court had said to the Trump administration, you must facilitate and effectuate returning people. And the Supreme Court said, all you have to do is facilitate it, right? In other words, if we allow courts to tell the Trump administration to effectuate that, that would step too deeply into the executive power, right, to govern foreign affairs. And our US courts are not allowed to do that, right? Only the executive can do that, right? That's your power, Trump administration. The second thing that the Supreme Court did was to say that the solution was procedural, not substantive. It didn't say Trump has no power to use the Alien Enemies Act. It just said that if you want to do that, at least initially, you have to give them notice and a hearing. And so the first thing the Trump administration did when Abrego Garcia was returned to the United States was to find the most favorable tribunal the Trump administration could find, and that was the immigration courts, right? And the immigration courts have now been purged, or are being purged, and refilled with Trump loyalists. And sure enough, they have denied his asylum application, retroactively ordered him removed based on a prior proceeding, and the only thing that has kept him from actually being deported is other courts have stepped in as well. So I think the accumulation of power here is not just in the legal frameworks that the Trump administration is tapping into, right? The accumulation of power is also in the level of fear, right, that these actions have actually taken that are impacting particular communities, communities of color, Latino communities. Because it worked, right? The Venezuelans are gone. They're in Venezuela. Abrego Garcia, the question here is not whether or not he's going to stay in the United States. It's which country he's going to leave to. That's what the legal fight is right now. Okay, let's hop over to mass deportation infrastructure. And I want to do this one relatively quickly because I think, because I actually really want to get to the EU pushbacks. But there's not a whole lot more to say about this, but there's one really important thing that I want to point out, right? Mass deportation, this is a situation in which the Trump administration says, we are going to implement the greatest deportation program ever in history, declares a national emergency at the border, deploys military resources, border patrol, et cetera, et cetera. So how do you quickly deport over 11 million undocumented residents in the United States? You need a lot of arrests, a lot of detention, very little process before expulsion occurs. That's pretty much the only way to do it, and that's what we started to see in American cities throughout the United States, right? So they actually started in Chicago, Portland, Oregon, where I live, and Minneapolis, I think, has been the one that's created the biggest media splash. In other words, what the administration did was to take a very militarized response to trying to make this happen. No warrants used for vehicle stops, lots of smashing of windows, occupants hauled out of cars, arrested without further questioning, and I mean, kind of name your human rights violation is where we are now. So I've, again, thrown a couple of them up here on the board, but human rights experts more knowledgeable than I could probably actually do a better job of even laying out quite a panoply of human rights violations. So where does this get the Trump administration? I'll just say this, right? In one of the things I think that this set of human rights violations allowed the administration to do was to use some of the power aggregating rhetoric about internal invasions, flood metaphors, eliding immigration and criminal law to criminalize Latino and undocumented immigrants and render them national security risks. And this is actually related to my conversation with Juliet after Juliet's presentation. we started off with this very militarized response, especially in Minneapolis. And we ended up with the Greg Bovino response. And we ended up with the Thomas Homan response, where we don't have smashing, we don't have smashing of home windows and that sort of thing. We've just taken it down a notch to warrantless, racialized, largely workplace-based raids. Okay? Before the Trump administration came in, these would have been seen as quite shocking, right? It taps into similar kinds of legal frameworks, national security frameworks, criminal law frameworks, immigration law frameworks. But now things are better, right? We still need the state of exception because of these power accumulating legal networks. But now things are better, and so it's easier to get to that state of political indifference that Hannah Arendt talked to us about. So one question that I have, and maybe this is a question for you, is this happening here, right, with the pushbacks in the EU? And to some extent, I don't have to answer that because Marie Lauer actually already has. I've relied quite heavily on her 2025 article, Applying Foucault and the Theory of Domination to the EU pushbacks. So I've thrown up some of the types of human rights violations that have been identified in her work and others' work. I've also been reading Irina Fair's work on the Croatian pushbacks there. And these, I think, the ones that I've listed up on the board are really just what was happening in Cyprus. But the question is whether or not these kinds of violations of human rights allow that kind of aggregation of autocratic power, the violations themselves. And I think in Marie Lauer's application of Foucault's theory, she says some things that are very useful to my analysis, right? She concludes, pushbacks keep immigrants on the edge of the physical territory and at the margins of the state's legal jurisdiction, right? That's where we create that state of exception on those margins of the legal jurisdiction at the border, right? At the physical border and at the border that keeps getting pushed both outward and inward. She says thick borders both isolate a field, allowing authorities to concentrate their power and enclose migrants, and expand a zone, letting control, surveillance, and rejection be spread and asserted. So I think we really start to see this playing out in the justifications for pushbacks. In Irina Fair's work, they resonate in securitization, of course, security of borders, in immigration law, of course, irregularity of entry, but also in criminal law, right? So Fair reveals the criminalization of taxi drivers who were transporting the migrants being accused of smuggling in the criminal justice framework. And NGOs as transporting or facilitating in criminal law, right, facilitating these immigration violations. But I also wonder whether, and this is my last point, whether violating human rights makes it easier to accumulate other types of power. In other words, if we can't control our borders because of human rights, right, we've been pushed back on our pushbacks because of human rights, then we need to take other measures that accumulate power. For example, these are just a few examples. We now need to digitize everybody who's crossing European borders. We need to exercise power extraterritorially by entering into third country agreements to prevent people from arriving, regardless of whether those third countries might commit human rights violations. And we need to reconceptualize the border by, as Marie Lauer puts it, deploying fictions of non-entree that excise the territory, expanding borders within the national space. These are not collateral to human rights violations. They are responses to them that justify collecting extraordinary power. And I'll stop there.
Thank you very much. Thank you so much, dear Juliet, for your very brilliant presentation. I had in mind this very old principle that we use with international law, ex injuria jus non oritur principle, which means literally illegal acts do not create law, or not supposed to. So you just demonstrated that the opposite is actually happening in the US now. Thank you very much.